Thank you all for joining us this afternoon for the presentation on licensing, legal, and land use, our favorite subjects. My name is Stacy Laux, and I'm the Executive Director of the Denver Department of Excise and Licenses. Excise and Licenses has over 100 business licenses. We're the business licensing and regulatory agency for the city. We have over 100 business licenses, 8 of which have to do with marijuana.
Good afternoon, everyone. My name is Jill Jennings-Golick, and I'm the Deputy Director for Community Planning and Development with the City of Denver.
Oh, right. Hi, I'm Tina Axelrad, and I'm the Zoning Administrator for the City of Denver.
Good afternoon. My name is Rebecca Watada, and I am a Senior City Attorney with Denver.
Hello, everyone. Hope everyone had a good lunch. My name is Reggie Newbine. I'm also an attorney with the Denver City Attorney's Office.
Hi, I'm Sherry McLeod. I'm with the City of Seattle, and I'm the Marijuana Coordinator.
Hi, I'm Victor Salinas. I'm with the City of Portland, and I'm a coordinator for the Marijuana Policy Program.
Thank you all. This first slide is a city comparison between Denver, Portland, and Seattle, just on some basic fun facts and figures about how the 3 cities compare. You will see this slide again before each of the presentations from the different cities, but I thought I would just walk through Denver real fast. We have over 680,000 people that now live in Denver, 16.4 million annual visitors. I'm sure that you've heard a theme about marijuana tourism, so that's our fact and figures for where we are today. Parks and green spaces, we have 20,000 acres of parks and green spaces, and one of the lovely and unique things about Denver is we have a really impressive mountain park system, which includes Red Rocks. We have a ski resort at Winter Park that's all part of this and helps to contribute to the acreage that we have as part of our mountain park system. Percentage of marijuana businesses in the city from the state total. This is one that we always concentrate on because we were the first city in the state to opt in to allow retail marijuana, and we have 37% of the licenses throughout the state just within our borders. We have just over 1,000 marijuana businesses that are licensed within our city, and we have 8 different marijuana license types. So we license stores, grows, MIPS, and testing facilities.
We're going to start off the session with an overview from Denver of how our regular system works together to direct the location and land use of marijuana businesses. And I guess I have to do 3 things at once. So I just want to set the stage with a little bit of the history of how Denver got to where it is. Like a lot of places, we had to make a choice, fork in the road, when it came time to adopting regulations for marijuana businesses back in 2010, late 2009, which part of the municipal code would take ownership of regulating these new businesses. Our choices were essentially to look at licensing and zoning. We felt those 2 regulatory systems would do the best job in terms of directing the location, particularly of these businesses. Uh-oh, that was my timer. Sorry, I'm done. I'm supposed to be done. I'm sorry.
It's a lightning round.
Generally, our scheme for regulating marijuana, a very conscious and debated choice was to have primarily a licensing scheme with a nice little dose of zoning mixed in. But licensing would be the primary vehicle for regulating the operation and location of these new businesses. Licensing does a good job, and we felt better than zoning in terms of being able to reach the scope of operations and the character of the operator, plus its enforcement tools and scheme is generally quicker and easier to enforce than zoning. One scheme deals with the privilege of doing business, the other deals with property rights, and it's typically always harder to revoke or suspend a property right than a business license. So with that came a decision on the zoning side not to create any new distinct land use types or categories for marijuana business. On the zoning side, we fit and translate all the marijuana licensed businesses and types, the growing, the processing, the selling, the testing, into an already pre-existing zoning land use type. In other words, we treat them just as any other land use, and again, that's philosophically consistent with how zoning works in Denver. We look at a land use sort of blind to the owner and operator. Instead, we look to how well it fits in with other uses, other adjacencies, and what potential external effects it will have. We're trying to focus primarily today in this second year symposium on the lessons learned. Generally, one of the critical lessons that Denver learned the hard way, and for those of you more on the edge of leaping in as opposed to already leaped in, we hope this is a good lesson for you, not to repeat. Timing is everything. Colorado found itself at a place when we needed to adopt marijuana licensing and zoning rules when there were already existing businesses open and operating. Our marijuana rules, as you know, come from our Constitution, so the right was there, but our regulatory scheme lagged behind. So at the same time we were creating new marijuana licensing rules, we were updating our zoning code and rezoning, remapping a lot of land. Meanwhile, there were existing marijuana businesses on the ground. On the licensing side, there was a decision to essentially grandfather those pre-existing licenses. But on the zoning side, we had a subset of those pre-existing businesses that, as a result of zoning changes, were no longer permitted in the zone district in which they were located. So we had this wonderful confluence of grandfathering and nonconformities, and it's a little hard to mix those two things together. We don't recommend you do, or that you maybe think out the consequences more. I think we're finally there in the last 2 years getting a grip on how to handle the conflagrance of grandfathered pre-existing uses from both zoning and licensing. But what happened was some licensed businesses or grandfathered businesses under the licensing had never legally established themselves under the zoning, and we actually had to go out and shut down a large number of these businesses. And then if you're a non-conforming marijuana grow, for example, or retail store, it was mostly on the grow side. We have very strict zoning rules on your ability to expand the use. So in an evolving industry like marijuana, that hurt. So some businesses found themselves non-conforming, not able to expand, and stymied in their development.
So the way it works in Denver is to go apply for a license, you have to have a zoning use permit. And when licensing regulations were set up, they referred specifically to specific zoning land uses for the specific license type. So the chart you can see here outlines the various license types for retail or recreational, and then the corresponding land use that was codified in the licensing regulations to go along with that. And what we found is we actually weren't keeping up as the marijuana industry was evolving and extraction became a huge component of the business here. We weren't prepared from a land use perspective. And so in 2015, we had to make changes to our zoning code as well as licensing then to go along with that, to factor in the types of extractions with hazardous materials, the butane, the CO2, that we were starting to see that our land use code really hadn't factored in. Extraction really was more like perfume manufacturing, which for Denver is a heavy manufacturing use. But the licensing regulations didn't figure that as an allowed land use for that license type. So we had to make those changes and fix both of our codes to address this evolving industry. Another lesson learned in terms of the interplay between licensing and zoning is that even though we in zoning might allow a marijuana store to go in a certain location under a retail sales use, licensing actually has regulations that prohibit in certain smaller scale commercial zone districts a license from being issued for a marijuana store. We're actually working, hopefully next year, to make a tweak to our zoning code to put in a new limitation to catch that so that we're not issuing zoning permits for something that can't eventually also get licensed. And then as part of our ever-evolving world this year with new regulations and caps that went into place, essentially new licensing controls that are really taking the function of land use regulation in terms of separation from residential zone districts has now been codified in licensing to try to further separate growing uses from residential zone districts, which will add a new interesting twist to our regulatory world. So that brings us to watching out for loopholes. We in Denver have a number of agricultural land uses that allow growing plants that really weren't specific. And our original land use didn't specifically, as Tina had mentioned, call out marijuana. But we had a number of land uses under which one could grow marijuana, and the only clear tie was in the licensing regulation that referred to plant husbandry as being the allowed use. So in 2013, we did a zoning code amendment to make it very clear that if you were growing marijuana, it had to be done under the plant husbandry land use, and it had to be in an enclosed structure. Because we could issue a zoning permit for an urban farm and make no reference to whether you were growing tomatoes or whether you were growing marijuana.
So, in theory, everything works beautifully, right? You think you can make clean splits and push these two systems apart, and one side will do their thing, and the other side will do their thing, and it should just work beautifully, right? So I guess, the overall big picture lesson is, no, not so much. It's a little messier in reality, and sometimes where we thought, we don't need to mention marijuana in the zoning code. We need not taint our zoning code with the words marijuana. No. I mean, ultimately, we had to make those links and connections to make sure the system as a whole really worked the way we intended. Another lesson learned, besides the loopholes, were just gaps. As you know, licensing is typically regulating a business, the operation of a business, a privilege of doing business in the city. And there's a lot about marijuana that has nothing to do with running a business. There's a lot about marijuana that's just about personal use and not selling it or wholesaling it. We were a little slow on the uptake and had some gaps where we had to quickly move to fill in where licensing just had nothing to say about, for example, growing plants at home or growing outside your home in a collective in a warehouse but with no intent to sell. So you would not need a license. So home grows was the first thing we realized pretty quickly we had not addressed. The Constitution in Colorado gave you the right to have 6 plants if you were a primary caregiver, and then with recreational, if you could grow 6 plants at home. Well, 6, per adult or per person could be a lot of plants in a single household. So we jumped in based on police activity and inspections to date, where was that tipping point between really truly a personal grow at a scale that was accessory to your home, incidental, secondary zoning terms, versus tipping into, boy, that's starting to look like a commercial grow. How could all those plants be just for personal use? And we had to put some bright lines, and so far they seem to be holding. But generally for at-home grows, our limits say no more than 6 plants may be grown for each medical marijuana card holder or for each adult over 21. So we've got both the medical and recreation covered. And those folks had to be residing in the dwelling unit where the grow is occurring. And even more so, it's not on the slide, no more than 12 plants per dwelling unit. So you might have 4 card-carrying medical users in a single household or apartment. And, if we didn't have the max 12, all of a sudden it's not 12, it could be 36, which seems well beyond a small home grow. It has to be completely enclosed in a structure. If you're in an apartment building or condo, the common areas cannot be used for growing. And we put that the grow has to be for personal use, no sales allowed. And so far, we're using our best attempts, and we have a lot of enforcement activity, but this helps to have these clear lines drawn. Did I go the right way? The other gap, as I mentioned earlier, with these non-licensed collectives and caregivers, people get very creative. You might not have the space in your home or the desire at your house to grow. So what do? You look for space, and you start your own greenhouse, and maybe you get a couple caregivers involved or other adults involved. You have no intent to sell. We started seeing these pop up shortly after implementation, so we had to quickly move, and it was a sort of combination of what's criminal activity. That's my timer. I'm really supposed to be done now. And what's part of this collective. So we passed in our criminal code no more than 36 plants, but we used a zoning term to sort of try to contain it on any given piece of land. So no more than 36 plants on a single zone lot in a non-licensed facility. A zone lot is just our term of art for a buildable development site. So you might have 4 buildings on a single zone lot, but we're still going to only let you have 36 plants.
So a quick recap on some lessons learned from a land use perspective. As Tina talked about, that timing piece is everything. Don't have multiple regulations being updated and changed at the same time, because it creates a lot of complication later on when you're actually trying to implement. Non-conforming uses, grandfathered licenses just become really difficult to track as these businesses have changed hands over time quite a lot. And, from a land use perspective, zoning isn't really nimble. It's not really easy for us to quickly make changes. There's usually a lot of research involved, drafting, public outreach, communication, and then the whole city council adoption process as well. Best case scenario, it's 4 to 6 months for us to make a change on the land use side. And that's if we know exactly what we're doing and exactly what we're drafting. So we've had to work through interpretations, followed by text amendments to be able to react to these changes in what is really an evolving industry. It seems to change every month or two in terms of what they're doing. And then as Tina talked about, there are a lot of loopholes and gaps. When we were set up really on a license-based system, that doesn't factor in what our Constitution allows in terms of the caregivers growing at home. One of my favorite questions that I got at our permit counter was, well, it just says 6 plants, so I can have 6 in this stage, and 6 in this stage, and 6 in this other stage. And granted, I didn't know what all those stages were, but it was very clear. No, 6 plants is 6 plants. It doesn't matter what stage they are. And then finally, I think especially with Denver, with our overlapping system of both licensing and zoning, what's really key is ensuring, a good training and administration. Licensing folks don't know or necessarily understand our zoning code, and we don't know and understand the licensing regulations. And I think having minimum understanding between both staffs of what each is responsible for is really key and critical to that. And then from an enforcement perspective, our zoning inspectors weren't originally involved in the marijuana licensing. And so now today, with all of the transfers that are happening in this industry of ownership changing one way or another, our inspectors are involved in those inspections. And so we're often on site and we find zoning violations because things weren't inspected originally. So I think really thinking about that enforcement component up front and who's going to be involved and getting the right enforcement group involved from the get-go is going to be really important to ensure you're not dealing with problems later on as we are.
So I'm sure you've heard a lot about kind of the chronology of what's happened in Denver. Marijuana was originally, the vote happened in 2000 for medical marijuana, but medical marijuana stores began opening after the Cole memo in 2009. When stores began opening, we did not have a regulatory system in place at all. So stores would come in, or businesses would come in and we want to apply, and we didn't know what to give. So we'd be like, is that a wholesale food license? What is that? So we were trying to issue existing licenses that we had out of our 100 licenses within the department And then we worked quickly to adapt, and we at that time created as a dispensary license. But lo and behold, people are coming in and not applying just for dispensaries, but for grows, for kitchens. And so we went through and created a retail marijuana code, a medical marijuana code. And then in November of 2013, the voters passed Amendment 64, amending our state constitution, and we had 6 weeks to put in a retail marijuana code. And I just want to kind of put back, when you have 6 weeks to put in a code, it takes 6 weeks to get through our city council process. So we basically had about a week to come up with a code to be able to put it through city council in time for it to be able to take effect. So we were definitely trying to adapt as quickly as possible, but sometimes those aren't the considerations that the voters give us when they pass new laws. And then since then, we've passed a number of bills, most recently the omnibus and capping bill, which kind of gets into the locations of businesses, which you'll hear more about. So when Amendment 64 passed allowing retail marijuana, cities and counties were given the ability to opt in. So this chart just shows kind of the concentration of the local jurisdictions who have chosen to opt in for medical and for retail. And again, kind of referring back to that slide that Denver has about 37% of the licenses for the entire state. As I mentioned before, we now have 8 license types, and that's been a series of ordinances that we've changed. Most recently, we added actually medical testing facility licenses. That was something that the state changed in the last legislative session, so we adapted a couple months ago to create a medical testing facility license. In Colorado, and the way Denver has chosen to implement marijuana, it's essentially a dual license system, trying so hard to mirror our liquor licensing system here. So for retail marijuana, you begin your application at the state does their review, and then if it passes the state kind of background checks, financial solvency, and the other reviews that the state does, then it kicks down to the local jurisdictions. And then we begin our quality review to see if the application can then continue through the process. So this is just a chart followed with this second slide of just kind of the basic process that an application will go through in the determination before it can go to a needs and desires hearing. Just to kind of give you a sense of that previous chart, the background of the process map, here's just an average length for an application review. We first have our chief inspector review applications, and this is one of our biggest lessons learned. We now check for proximity at the beginning of an application. We were at a system where you would apply, we'd review leases, go through things, make sure you had your surety bonds, all these things, and then at the end of the process, we would send our inspectors out, getting ready to issue, once the inspection card is issued, and then they would do the proximity measurements. But lo and behold, we would be fined, you're 1,000 feet from a school, you're 1,000 feet from a daycare. And at that point, months have passed. So one of the changes that we've made to our processes is we now do those proximity checks right at the front. So we don't go down the road, and more importantly, the applicants don't go down the road just to find that that's not a location that they can ultimately pursue their licenses at. So we have our inspectors. We do GPS, and we also will do a manual measurement. We also have the city attorneys review the applications, and that takes about 2 weeks on average. So it takes about a month to really do an in-depth review of the application. And remember, just as what Jill was saying, is by the time the applications come to us, they already have gone through zoning, they have their zone use permit, and they've already had state review. So here's just a breakdown of our almost 1,100 license types. You can see what we have most of as of this week. Medical grows, and then of course retail grows, and then it goes down to medical testing facility licenses. And like I said, we just created the medical testing facility license in February. And just as Jill alluded to, that was great. When we kind of had that 6-week exercise to get ready for retail marijuana, we created new licenses and we were ready to go on day one. January 1st, 2014, we were issuing licenses for retail grows and stores and MIPS. The one thing we didn't anticipate operationally was how many other transactions we would be working with. And so that's when we began tracking the transactions that were really coming into our office, the corporate structure changes, the transfers of locations, the transfers of ownerships, which there's a lot of, and the modification of premises. All of these, and especially transfers of locations, we treat as a new application. So if you're transferring a location, you're from location A to B, so then you have to go through and get another zone use permit. We have to coordinate with the state. We have another needs and desires hearings. A lot of that stuff we kind of had to make up on the fly, and then make sure it was codified appropriately. We just didn't anticipate that. We were so getting ready just to issue new licenses that we had the architecture and the infrastructure for that concept, but we weren't necessarily expecting how much of a load it would be on staff and on our resources for all the other types of transactions that are coming through our department. So we conduct, much like liquor, for a new store, a needs and desires public hearing, where the community can come and you have to establish that there is indeed a need and desire in this particular neighborhood to open a marijuana store or center. So this is a true needs and desires we've been doing in 2016. So this is the data that shows how many hearings we've had, how many uncontested hearings we've had, how many contested hearings, and how many contested hearings that have resulted in denials of the application. So here's sort of our lessons learned slide. What have we reacted to, and what is the best knowledge we can impart, and anybody else who's jumping into this or wherever you are? We indeed had to staff up. When marijuana came to us in 2009, 2010, 2011, we were in the depths of the economic recession. We were actually laying off city employees. So we had to figure out how to absorb this incredible new license type, an incredibly new complicated license type in 6 weeks when we were actually laying off employees within our department. So now that the economy has changed and revenue is coming in and we can react to actually the demands of the workload, we have indeed staffed up. We've added about 30% of a workforce to our departments, just in terms of all those transactions you're seeing. If you have 1,000 business licenses and then you have another 1,000 transactions with all those corporate structure changes and things like this, that's a pretty dramatic impact on our counter operation and also on our inspections, if you think about our inspectors having to go and visit those sites a couple times a year. We, with the marijuana policy team, had to hire a PIO. We received so many media inquiries, and our department never had a PIO before. We're business licensing. We always kind of stayed under the radar. But it got to the point with the media inquiries and with all the open records requests that we had to have somebody that could help manage kind of the public-facing data inquiries, that type of thing. And like I said before, we added hundreds of new inspections a year to what we were already conducting. And that's where the dashboard and the data, and hopefully you had an opportunity to hear Nitya speak. Having a dashboard and the data analysis has been what has carried our department through in the last number of years. It's how we can justify adding those new positions when we make the budget requests. It's how we can justify sometimes to the applicants why it's taking so long, because we have all this data to show what's happening in the department. It's how we can really show what we're doing internally and meeting those metrics of how can we get down from 60 days to 31 days for an application review. We look at our dashboard daily. It is something that we have to be able to make those data-driven decisions, and that's ultimately how we can, try and even begin to pretend we're a successful model. It's really just because of the data and the dashboard. But when you have that data, the most important piece that you can do with it is make it public facing. So the other kind of half of that coin that Nitya has done incredible work with is making that available to our community members. Being able to, again, show our wait times, being able to show the workload, being able to show how many licenses there are. Before we were automated on Acela, we had paper files, and just as Jill was saying, an applicant would come in and you'd write down, all right, your business file number 1-777342, and then a change of ownership and a change of location, and trying to figure out, well, when it splits up, does this file now split up in 2 ways? Which goes here? And with the technology and knowing that we needed to be accountable to our community, having that data, having Acela help formalize it, and having the information available has been unbelievably helpful for us ultimately. We had to shore up our business practices, and that kind of comes back to the automation piece. And it's taken us a lot of time, and we're getting there, and we still have a ways to go. But codifying our practices has been most helpful. And just as Jill and Tina were saying, we didn't even think to talk to enforcement agents and inspectors when we were first coming up with these new license types, because again, we had 6 weeks. And so now that's our lesson learned, and now any change that we make, we communicate widely with our own team across the city. We had to do a cash handling policy. Marijuana, especially in the early years, is all cash driven, so people would come in with $20,000 in cash to our counter, and we weren't equipped to handle that, so we had to quickly put in a cash handling policy. Some things like that have changed, but with that, we had to put in pretty strict security improvements and safes that had to be larger to accommodate the industry. We also had to put in PII, personal identifying information protections. We had a lot of debate. Do we show where grows are located? Do we put those maps out where grows are? Because they might be, a target for crime if people know that that's where a grow is, or a lot of cash is being held on hand. So we've had a lot of policy and really interesting conversations about what we want to make available. How much do we want to make available about the ownership information and that type of thing? Standard work, that's just a government practice, that this is just like everything else, but incredibly important because it's such an interesting and such a highly scrutinized license type. And then, of course, one of the most important lessons learned is we have an incredible synchronicity with the state and the state coordination, and that is just essential when you have anything like a dual licensing system. I think with that, we have a couple things that are heading our way. And like I said, we've had a number of ordinances, I think of 5 or 6 ordinances that we've passed strictly pertaining to marijuana in the last 2 or 3 years. And we have a handful that may be coming through. Yeah, and then.
I'm a stander, so I don't know that my microphone was working before. I have a pretty good projecting voice, though. My name's Rebecca Wattada, and I'm a senior city attorney in the Denver City Attorney's Office. I have been a prosecutor. This is going to sound a lot like what Marley was saying yesterday. My background is prosecution. I'm a prosecutor at heart. I started out in Weld County, and I was there for just under a year as a prosecutor in Weld County, and then I was a DA here in Denver for 10 years, and have recently joined the City Attorney's Office in the marijuana unit. First of all, everybody says that everyone says this, and I'll say it again. It is collaboration in terms of what you're going to be doing with licensing, regulation, compliance, enforcement, all of it. But it's collaboration, even though we have all these city agencies that are talking to you today. It's collaboration with the industry. It's collaboration with others that are outside of just even zoning and the fire department. It is huge collaboration and communication. So that's something that's very key. As it relates to the City Attorney's Office, the City Attorney's Office in Denver has 6 sections. We have over 200 attorneys and staff. The marijuana unit is sort of housed within the prosecution and code enforcement. Also within the prosecution and code enforcement unit of the City Attorney's Office is excise and license unit. So the marijuana unit, it's kind of funny sometimes I think about it, we're in the prosecution and code enforcement, but the marijuana unit we're regulation, we're compliance, we're enforcement. And it is a team that has started out with Marley, one person in the marijuana unit, then came on Anshul Baga as a fellow. He then got hired on, and then we got Reggie Newbine as a fellow. And then he got hired on, and then we got me as a senior attorney in the unit, and then our paralegal, Brian Snow. It's a really great unit that every day we're having a conversation about what the law means today as it relates to any given question that comes up from licensing or otherwise. So there's always something new challenge, and it is literally every day something new. So lessons learned are every day and all the time. But it really is very much an interagency coordination between our office and the fire department, zoning, Department of Health, the police department, the building department. So this is sort of the legislation, a timeline of the marijuana legislation timeline to date. That first portion of that slide, the retail conversion from medical. It's actually about 2013 to about 2016. It really is different now. But initially, it was we only allowed a retail retail marijuana store conversion from an existing medical. So you had to have had your medical in order to get that retail. And back in 2013, when we started getting retail on the ground and started running, that definitely created a pipeline, if you will, of applications of individuals who had a medical license that were converting to a retail license, because that's the only conduit in which you could get that retail. That kind of continued on, and my slide is a little too cut off there. That also, at that time, though, we also continued to accept new medical marijuana licenses applications. So then by December of 2015, the City Council had put in place a moratorium on all marijuana licenses. And this was sort of a time to step back, reflect, kind of be able to look at the saturation that was going on in Denver and hear from the community, hear from the industry to try to find out how we can keep the industry going, keep the community happy, keep the streets safe, and sort of have a collaborative effort. So there was a moratorium in December of 2015 in which all new marijuana license applications by 12/31/15, I'm sure there was a long line on that day. After that day, there were no new applications coming into play. And at the same time, what was going on as City Council started putting in place the convening a marijuana special issues committee to look at all of these issues and have those conversations with the community, there was also talks in sort of the next slide of the omnibus bill, the cleanup bill, if you will. That was starting to also take place. And there were meetings going on from about September, November, and with working groups from the industry and from the different groups throughout the city to sort of see what needed to be cleaned up in our initial bill and moving forward. And Reggie will talk a little bit more about the specifics as to what that did. And also during that time, through those conversations and what City Council was kind of hearing was that to take care of and started to contemplate how to improve the saturation, improve the community's satisfaction with what was going on in their communities. Ultimately, also, a cap bill was put in place in May of 2016. So this sort of is the pre-omnibus bill. What ultimately happened as you have a couple of years going in marijuana and licensing is we determined there were issues that we had not foreseen as discussed in zoning, the zoning presentation, but just new things pop up every day. And so there were amendments being made to the state code, our sort of experience and what we'd learned from licensing, and so we started going into the making and creating the omnibus bill. What ultimately happened was the omnibus bill was a 43-page complete overhaul of the medical and retail marijuana licensing code to the Denver Revised Municipal Code. It cleaned up a lot, and now we already are on chapter 2 and a whiteboard of new stuff that we're going to have to start working on in the next couple of years. But that's sort of where we come to in terms of the omnibus bill. And Reggie's going to talk to you about the omnibus bill and the capping bill and more of those details.
Thank you, Rebecca. Hi, everyone. Again, my name is Reggie Newbine. I'm also in the Denver City Attorney's Office with Rebecca and Marley, Anshul, Brian over there. Also, our fellow Stu. He's on track to be the next new hire, I guess. So some of the major issues that we tried to get with or tackle in this omnibus bill were really consistency. We saw a lot of differences between what was going on in the state, versus what we were doing on the local level. We wanted to kind of shore up those processes and make us more consistent, make us more like liquor, like Stacey was talking about a little bit earlier. We also noticed there were inconsistencies with how we were treating retail versus how we were treating medical marijuana, and wanted to bring those two closer together and make those more aligned as well. Also, we wanted to try and correct some of the inefficient processes, and we've been doing this for about 6 years now. This whole industry has been going unregulated for about 10 years and then regulated for the past 6 years. And we hadn't had a major update to any of our bills for about 4 years. So that's why this was an overhaul, a 43-page overhaul of just corrections and things that we had learned. And finally, we want to address get more input and collaboration for the community and allow them to have more of a say in the licensing process. Let's see. So specifically for consistency, one of the things that the omnibus bill required that in order to obtain a local license, you need a state license. And for us, that's clear. It wasn't in the code, and so one of the things that this did was really give clarity to the industry in the sense that they know now that if you don't have a state license, you won't be approved for a local license yet. Also, anything that happens to your state license, the same thing is going to happen to your local license. Earlier, Brian and all of our inspectors and DPD team talked about how if you have disciplinary action on your state license, that could lead to a show cause, and that could lead to a revocation of your local license. At the state level, the same thing could happen. You could have disciplinary action from the MED. They could find out that you had diverted a lot of plants out of state. You could lose your state license. We wanted that same kind of thing to happen at the local level as well. Finally, the state changed their changed how they would do product management for retail marijuana grows. You could have multiple state licenses or multiple retail grow licenses at a single location. Those all would collapse into one license. We wanted that same kind of thing to happen with a local license. We didn't want you to be able to have, one state license, one state grow at a location, then have 5 local grows at that location. It didn't really make sense. So we wanted to have that consistency between the state and the local level. Also, there were a few things just on the medical side that we're not in ordinance, but we treated them that way, such as hours of operations for centers. Prior to the omnibus bill, we didn't have those hours in there. We left that up to the state, but wanted to go ahead and give that clarity and put that in there. Also, all of our measurements weren't conducted by a straight line measurement. For a few things like proximity to centers or other stores or other sales locations. On the retail side, we did everything as a crow flies, but on the medical side, if you were too close to maybe a school or a child care facility, we would measure by a pedestrian access. And then we changed that over to as a crow flies, so they were all consistent. So really, one of the big goals that we wanted to just address was just making sure everything was consistent across the board. So another thing that we really noticed and that we wanted to try and account for in our omnibus bill was kind of updating things as far as lessons learned, right? Like I said before, we'd been doing this for about 4 years, so we were overdue. As far as accounting for the unexpected, we wanted to make sure that we could shore up our process just in case things did not happen the way we had planned for them to. We wanted to make sure that if there were we had some issues with what happens if you discover new information after you send out documents saying that everything might be fine. We might have had issues, maybe we needed more time with decision making. We wanted to put all that information into our code to, one, have that protection, but also to let the industry know, if a decision isn't made in 30 days, it will come, and that's not to say that the decision is that you're granted. We also noticed the inspectors talked a little bit about this earlier. There might have been issues with not being able to really know what the licensed premises were. So we added new application materials in the sense that if you are applying for a license, we really need to know what your license permits look like, outlined in red. If we have people going in there to check this out, we want them to be safe, we want our first responders to be safe, and we want all things to be copacetic, right? We also put in deadlines for completion of, that should be applications, not applicant, I guess. We had a number of applications that were being filed in the department that had aged, upwards to a number of years. People would probably come in and apply, maybe forget they had applied. Not really sure why you would forget after you're spending all that money, but it happened, and we had a number of aging applications, and so we had to figure out what to do with those if they were over a year old, right? So we put in a new requirement that you had a year to complete all application requirements. And if you needed more time, you had to come in and request that time. So it was really a way for us to be able to check in on the industry, check and see if they were actually going for licensure, and if they needed that additional time, we had eyes on the situation. We also noticed a lot of gaming in the system. Sometimes folks might get halfway through or almost through the application process, or really just have an application going on, and they would transfer the location of the application, of a pending application. They might transfer ownership of their application. And it became very apparent, especially after we stopped taking medical applications, that if you had applied before, that was probably something that was going to be very valuable. So folks might try and transfer ownership of a pending application to another person that could no longer apply. And so we put prohibitions on the transferring of new applications, basically said, no, you can't transfer a pending application. But we wanted to also we also wanted our director to be able to have discretion to consider these in some circumstances. And so while the prohibition was there was also a discretionary, if you can show good cause to why you need to transfer location of an application, you applied at this location and something happened with that location and you need another location, show us good cause, give us your reasons, we'll consider that, and she has the discretion to let that go. And then the final thing, which was a big push, was a move to a discretionary hearing for grows that were in non-conforming districts. Tina and Jill talked about this a little earlier, that when we first started the licensing game, there were a number of locations that were in districts that now they could not be in, but there's that grandfathering aspects. And before, it just wasn't one of the, an issue with not being able to expand your premises for licensing. It was also an issue of being able to even stay there at all. So we required, if you were in a non-conforming district, if you were a retail or medical marijuana grow that was in a district that was non-conforming, you had to have an annual mandatory hearing to basically show that, give your neighbors the ability to come in and voice their concerns, and it was on renewal every year. We noticed, though, that those hearings were largely uncontested. No one was showing up. It was just the applicant and the hearing officer and the city attorneys. So it was a really big lag on the department resources. And so we moved away from a mandatory hearing to a discretionary hearing. Still wanting to keep our citizens in the loop and have their input. So if they petitioned, got 10 signatures to have to hold a hearing. If they wanted to have a hearing, all they had to do was go and get 10 signatures, and we would hold a hearing for a grow that was in a non-conforming district. And we have had one, so it works. Not sure what I did. The final thing that we did was, the final thing that the omnibus bill was meant to attack or tackle was the need for more community input and collaboration from citizens, right? So a few things that it did was add hearing requirements for centers. Before, centers did not have to have a hearing. If you were applying for a new center or applying to transfer location of a medical marijuana center, you didn't have to have a hearing. There was no voice from the community that could come in and say, we don't need or desire a new center in this location. And so we changed that. So we've had a number of hearings for medical marijuana centers now. Just had a really long one this past Wednesday that went until about 11 o'clock and is still going to go on Monday. So we wanted to be able to give voice to our community members to be able to come in and say, look, if we don't want this here, we don't want this here. On top of that, we had a transition from what we call a health, safety, welfare hearing for stores to needs and desires. So prior to January 1, 2016, the only people that could get a retail marijuana store was a person that had already had a medical marijuana center. And so in that vein, what our code required was for anyone that wanted to have a store, you'd have to come in and show that the operation of your store wouldn't have a negative impact on the health, safety, and welfare of the neighborhood. Prior to this, we didn't do needs and desires because there was already a storefront there, and there were no stores, right? So it would be difficult to say that the neighborhood doesn't need one if there's nothing there, right? So afterwards, in 2016, we had a proliferation of stores, we had a proliferation of centers, so the neighbors could say whether or not they needed or desired an additional store on top of the ones that were already located in their neighborhood. And as you can see, and as Stacey talked about earlier, we have had a number of needs and desires hearings for these stores, new locations and transfers of locations. There have been a number of denials, which shows that, like, our community members are engaged, and they are very aware of what they do and do not want. So those were the three things that really the omnibus bill was try to address. On top of the omnibus bill, I lost my spot. We also passed the CB 160912, which we refer to as the CAP bill. So the omnibus bill really dealt with a lot of the licensing issues that we had seen across the city. Although it did speak to community involvement and collaboration from our community, I think the council also noticed that, outside of licensing, we have a lot of licenses in Denver. On the left side of the screen, these were just posts from our newspapers showing that there were a number of locations in certain areas of our city. I think on this side, it says like there were 620 entities in Denver, and the majority of them were located in the northern and western parts of our city. And then on top of that, we have 1,000 licenses. So it kind of became apparent that we were saturated, and we needed to be able to address that issue of saturation, and also address the issue that folks that are in communities that are saturated, give them the ability to become more involved and have a say in this process. So in April of this year, we passed the CAP bill. And what it did was it set a de facto cap on the number of locations and not licenses, that was deliberate, that would be available for marijuana businesses operating within the city. And so one of the things that we've kind of addressed this entire time is, make sure that you think about things like saturation caps and all of your licensing and regulatory structures on the front end and not the back, because one of the things that we could not do was really put a cap on licenses because all of these locations are already here, all of these businesses are already here. And so our best means of tackling this issue would be to have a cap on the locations and the number of locations where these places can go. So what the CAP bill did, it addressed the issues of saturation and community involvement. The goals were really good. In implementing it, we have discovered a few issues because the industry, if you are at a location, the only way that you can move to another location is if you move everything at that location, whether or not it's owned by you, or move to a location where there already is other marijuana businesses, or surrender everything else that's at that location. So the industry's kind of had to work through that, and we are working on implementing it. And On top of that, it also set a proximity restrictions on retail grows. Before that, there was no, other than our zoning restrictions, there were no restrictions on where marijuana grows could locate. One of the things the CAT bill did was restricted their ability to locate within 1,000 feet of a school by straight line this time, or 1,000 feet from a residential area. And that's also been going really well. On top of the saturation issue, the CAT bill also required community engagement plans. So if you are a new retail marijuana grow or store, upon application or transfer, you would need to submit a community engagement plan, which would discuss your plans for engaging with the community around you. It was an application requirement. One of the things that you might want to also think about if you are looking for community engagement between the industry and neighborhoods is thinking about how to make those enforceable on the actual industry. Right now, we have it as an application requirement, and we have gotten a few that aren't as good as what we would really like them to be. So if you can think of different ways to require that community engagement outside of just a plan, but also going out there and being engaged on the front end, that's something to really think about. And finally, the last thing that the CAT bill did was set a moratorium on new medical and also developed a lottery system. So if we ever do reach that, if we ever do get underneath the cap that we've set on locations, we could have new retail establishments, stores, and sales locations come within the city. And we will see if that happens. Finally, what's up next? So as Stacy kind of talked about, we have public consumption clubs. It's on the ballot this year. It's been approved for ballot circulation, and what it would allow for is a permit for any sort of business except for a marijuana business to be able to have a portion of their premises permit public consumption. This could also be what happened? It could also be a blue screen. And so it could also be a liquor license premise as long as the marijuana, I don't know what's going on with this. Okay. Okay. It could also be a liquor license premises as long as they aren't being consumed on the same actual businesses, because you would have a designated area of that license premises being used for marijuana consumption. So right now we're working on developing rules and regs just in case that does pass. And then the other thing, I'm not really sure what it was. Oh, and the other thing that we're working on right now is an update to our hearing policies and procedures for all hearings within the Department of Excise and Licenses. And is that it? Okay, cool. And that's it.
And now our friends from Seattle.
Hi. Hi, I'm Sherry McLeod with the City of Seattle. And first off, I wanted to thank Ashley and her team for putting on the second annual symposium on marijuana regulations. I was here last year and learned so much, and I was thinking this year, well, it's probably going to be a lot of the same stuff. And I was surprised. Every session I've attended, I've taken copious notes. And that's the thing with this industry. It's constantly evolving, constantly changing, and you have to stay on top of it. So this has been a great help, and I don't know where Ashley went, but she was a tremendous assistance to us right before we opened our first store in July of 2014, giving us an idea of what to expect with regards to crowd control, media, And again, we're constantly looking at Denver to aid us. In fact, we're even using the marijuana safety video for our inspectors to view, and we've actually bought new PPEs and have those kits set up, so when our inspectors go out, they'll be safe. So again, thank you to Denver and the Denver team. So first off, and that was it, no, just kidding. So first off, I just wanted to mention, it really has been a privilege to be in my position, to be at the forefront of something new and exciting. I've been doing it for 2.5 years, and it was mentioned in one of the first sessions, is that you can't put together this program in 6 months. My job was supposed to last 6 months to a year, and I've been doing this for 2.5 years, and I don't really see an end in sight. I think we have a really good beginning, but I don't even know where the end is. And it's a constant work in progress, so that's something you definitely want to plan for. It's not going to be a quick, oh, we're going to write the regulation, we'll choose a couple of inspectors, and off it goes. It really will not work that way. Do we know which way this goes? Oh, sorry. Did everybody get moved one? Sorry, can you go back one? Just wanted to discuss this really briefly. This is the comparison between the 3 cities. And you might notice, surprisingly, we're very close in population size. And then surprisingly, I was kind of shocked to see that we have substantially more visitors, but taking into account that's actually for our entire county and not just the city of Seattle. But again, surprisingly, we have very few marijuana business locations comparatively, particularly to Denver, but also to Portland itself. All the ones we have are state licensed now. We previously had up to a couple hundred medical dispensaries, and we might have been more on par with you then. But those have since closed. And I don't know if any of you attended this morning's session with David Mendoza. Excuse me. And you'll notice on the bottom portion, license types shows retail, producer, and processors. Those are the state licenses. The city of Seattle actually only has one marijuana business. We have a code that was effective last summer, and we decided to make it a general license that would cover all marijuana businesses. So should we have use lounges in the future, delivery services, we have a new one coming out, transporter license, those will all fall under the one license heading, so we don't have multiple different types of licenses. Yep. Clicker? Oh, thank you. So in Washington State, I-502, or Initiative 502, was passed by voters in November of 2012, and this legalized marijuana in the state. We did not have, and again, David had talked about this morning, we had a lot of medical marijuana businesses across the state, but we did not regulate them. There was an affirmative defense for the patients, but we ended up not doing any regulation of the businesses. So when we legalized marijuana, it was interesting. Everybody had to come up with new rules and quickly. We had far more than 6 weeks. In fact, I think it was 1.5 years before our first stores opened. But one of the items in the legislation that passed was a buffer. And so what I'm going to discuss next, I'm sorry, is land use, is a 1,000-foot buffer for marijuana businesses from what's called sensitive uses. And these include primary and secondary schools, public parks, playgrounds, libraries, game arcades, licensed child care centers, transit centers, and recreation centers. It's quite a long list. We've had people ask us, why weren't churches on there? I didn't help write the legislation. I don't necessarily know how each one of those were chosen. So between that, the state determined the buffering, but we're leaving the zoning up to the local jurisdictions. So Seattle began reviewing the land use code and came up with, and I'm sorry that this is quite small, I literally copied this out of our tip sheet, land use code to determine where the businesses could be placed throughout the city. Several of the areas do allow for all three types, and a producer is a grower, processor, may extract or create edibles, and of course retail. Between the buffering and the zoning, it was discovered that much of the city wasn't actually available to these types of businesses, and the value of the properties that are actually compliant went up and up, and we had landlords who really increased the rent substantially or put their properties up for sale for quite a bit of money. And we had businesses undercut each other. We had one who spent over a year, finally found a location that was compliant. It was a veterinary clinic. He began negotiations to buy the business. Another applicant swooped in, bought the building, literally right out from underneath them. So then applicant number one says, well, I'm going to move across the street. So he secured a lease in a space there that was occupied by a much beloved neighborhood business that had been there for 30 years, much to the unhappiness of the neighbors. And David had talked about this morning too. So applicant number two then opens a game arcade, because those are super easy to do. All you need is a space, lots of video games while you're off and running. However, it wasn't regularly operating, and we were able to determine that this was his attempt to game the system to stop competition. So it's hard to find compliant locations. So as we moved forward, oh, thank you. On this map, you'll see these are actually our retail locations. Okay. These are the retail locations that we have open, although as of today, the number is actually 40. The second applicant that moved into the veterinary clinic is opening today. Today's his grand opening. And the reason why I brought up this map is to show you the clustering effect. And this is what happens when there's restrictive buffering and restrictive zoning, is that the businesses are literally next door to each other, across the street from each other, leaving large parts of the city not even covered with a store, particularly in the south end, both southwest Seattle, southeast, and generally South Seattle. And in our attempt to disperse the stores so that there's equal access for all the communities that wish to obtain the product, whether it's for medical needs or recreational needs, we really needed to disperse these a lot better and throughout the city. And then just for the businesses to survive, they simply can't compete when there's too many of them, 5 or 6 within a 2-mile radius of each other. So the legislators did hear this, and as part of the Senate bill that was passed last year, one of the pieces was that local jurisdictions would be able to reduce the buffer down as far as 100 feet. So this is from 1,000 feet to 100 feet. David also discussed this piece. The city of Seattle did review 100 feet, 250 feet, 500 feet, 750 feet to see which would work best and not compromise the community. We settled on, and it went back and forth quite a bit with the community or city council, settled on 250 feet for the producers and processors and 500 feet for retail. However, in order to try to get stores within the downtown area where there are a lot of hotels, tourists, we needed to further reduce the buffering there for retail down to 250. So we were able to pass that legislation. Well, it actually wasn't passing the legislation, it was updating the existing land use code January of this year. And with that, the existing licensees quickly started submitting change of location applications. We literally, I think within 5 or 6 months, had 2 stores in that downtown area where we're really looking to try to place some stores. They're less than 1,000 feet apart, but each of them, the revenue is tremendous. So we know that we're supplying the need of the community in that area, the tourists that are staying in the hotels. There's a lot of nightlife in that area as well, but possibly also impacting some of the black market in that area. So as we move forward, we're anticipating more stores to move, and that clustering should actually start to disperse outward a little bit and cover more of the city and hopefully have more impact on the black market. And let's see. Sorry. Okay, this shows more of the buffering and dispersion. What I didn't mention was another piece that we updated in the land use code was dispersion, and this is to address the clustering. David, it's like we should have just combined our presentations. So we currently allow 2 stores per 1,000 feet. So if a third store wants to come in, it needs to be at least 1,000 feet from those other 2 stores. And this is measured straight line as the crow flies. However, all the ones that were previously licensed or previously applied are grandfathered in, which is pretty much everybody. So the ones that choose to stay can stay, but anybody who wants to move will need to maintain a distance of at least 1,000 feet. So the hope is that will discourage further clustering. One of the things hasn't been as big of a problem as clustering of producers and processors. We do not have a dispersion for those, and we have approximately 4 buildings in the city, large warehouses, most of them formerly heavy equipment manufacturing, that will house 4 to 5 marijuana grows or processors in them. The main concern with these places is the infrastructure, the electrical needs. 2 summers ago, at one of the warehouses, the transformer started to melt onto the sidewalk. Even though that had been steel manufacturing in the past, apparently it didn't use as much power as growing marijuana, so they did have to replace all that equipment. So that's definitely a concern. They might be moving into an industrial area, but did that industry use that much energy in the past? And just so you know, both this slide and the one before are available on tip number 134. It's available online. If you go to seattle.gov/DPD and or I think you can Google it, Seattle and tip 134. It's all the information on land use for marijuana businesses. Sorry. I'll also be talking about licensing today, and it is definitely a regulatory tool. Seattle is the only city in the state that actually has a marijuana license. We opted to do that, again, as David alluded to this morning, to help us regulate the existing medical industry that we had operating, and then moving forward, the new state licensed businesses, and then any other businesses that may come up. Sorry. I'm losing my voice. The license itself does allow us to address safety concerns, illegal activities, and encourage compliance with the city and state requirements. We do not use it to cap the number of licenses. The retail license cap that we have is actually set by the state at 48 stores, and Seattle is the only city in the entire state that's actually asked for more, would like about another 20 to where we feel will actually meet the needs of the communities. And then as for the producer and processor, the state originally set the limit not by the number of licenses, but by the number of square feet at 2 million square feet of canopy. Last I heard, it was almost up to 10 million. So the state has also had to adjust and grow and make the changes necessary to meet the needs. So our marijuana business license is an additional license that a business would need to have aside from their regular Seattle business license. In order to achieve it, you do need to be licensed by the state first, again, a dual license system. As part of the state licensing, though, local authority notices are sent out to all cities and towns, and it gives the cities an opportunity, a 20-day window, to object, approve, or have no issues with state approval of a particular license. This follows the same pattern as liquor license applications. So when we receive local authority notices from the state, that's the time when we begin our review. We look at the location to see if it meets zoning requirements, to see what the use is established for that unit or that property. Our city attorney's office actually does a background review of the individuals, and we take a look and see if they've had business licenses in the past, have they caught up on their taxes. So we do a lot of that preliminary review well before they're even licensed by the state. Once they are licensed by the state, we do contact them, actually contact them beforehand, but we contact them again with an application packet that includes that TIP 134 I mentioned to you, our application, and as much information we can get to them so they can actually achieve the necessary use permits. I don't know if you realize we have so much construction going on in Seattle, it could take up to 4 months to get an intake interview to make a change of use for your space. So the sooner these applicants can be, I can see these guys laughing. It's a problem in Portland too.
I was just happy we're actually not as bad right now.
I think all the cranes in the country are in Seattle. The sooner they can begin that process, the better it is for them, and they'll actually be able to open sooner. But the problem is, they don't want to put in the money and the time and the effort if they haven't been approved by the state yet. I mean, it's really difficult for the industry. They're outlaying quite a bit of money. So when they do submit an application to us, we do not have an application fee. We ask that they send no money. The way our licensing office works is any money that comes in automatically gets deposited. And the concern was that by accepting the funds, you are kind of approving it by, taking the money in. So all applications come in. If they do send in a check, it gets sent back to them right away. So we don't accept a license fee until we approve the application. And part of that review, since most of it was already done, we just checked to make sure no changes had been made since we did our initial review from the state. Once we do license them, we do send inspectors out. We have, they're called license and standards inspectors, and they have special commissions from the police department that allow them to issue citations, infractions, write search warrants, serve warrants, and file criminal complaints with our law department. So with our inspectors, we do try to go out to each business at least once a year, as well as follow up on any complaints that we may receive. Oftentimes, the inspectors are the first people that some of these licensees see, and they engage them and have questions, which it's really a good opportunity to stay and keep in touch with the businesses. Just this week, an inspector received a question about EBT cards. Those are the electronic benefit transfer food stamp cards. By state law, the cash machines in the stores, which you'll find every store has a cash machine, that has to be turned off. So one of the items our inspectors do look for, even though we have no authority to actually enforce it, is to let them know you need to make sure you turn that off, and oftentimes we'll ask them to do it right there. This particular business had the clothing store, pipe shop next door, and he had a cash machine there as well, and he wanted to know if he could keep on taking EBT cards there. So but I wanted to bring up that EBT card because I think a lot of people don't even realize that. I know in a lot of states they're not allowed in the ATMs at the casinos and I think strip clubs. I can't remember. But so that's just one of those things to watch out for. But the inspectors are oftentimes the people that these licensees will see first. So as I mentioned, our license does allow for our inspections, and if violations are found, we can cite the business, we can give them a verbal warning, we can give them a written warning, or we can cite them. Our fines range from $500 to $1,000. Second violation within 6 months, and that fine increases by 50%. Okay, sorry. So this will be, I'm going to try to hurry up. Sorry. So the first part of the items that we can actually cite for. The second part are state rules that we plan on adopting, and this will give us more authority over the businesses in the city. Oh, and as David mentioned also this morning, we also license businesses that come in from outside of the city, and this is particularly for the product that they sell. Our inspectors actually take a look at the products in the store, check the labels to make sure they have the necessary information. If the product is too small to actually contain that information, the retailer is supposed to provide, when asked, a piece of paper. Sometimes it's printed on the back of the receipt. That information, whether it's the pesticide that was used or the THC quantity or the dosage, because sometimes literally it's like a chapstick, so there's just no room. And these are just some of our compliance actions that we've done since August of last year. We've issued civil citations, we've denied 2 licenses, we've closed 120 stores, and these were medical stores that needed to close by July of this year at the very latest. We've filed with our city attorney's office 7 criminal cases, all on illegal delivery, and we did have to serve 5 search warrants and seize products. And we have ongoing investigations into illegal use lounges as well as sale of marijuana through delivery. Sorry. I'll just skip to the end. Okay. I think some of you will find you've already heard most of this or seen most of this because this keeps coming up. Be prepared if you know your state is probably going to pass it or might pass it, start planning now. Because once it passes, I suspect what's going to happen in your area is what happened in ours, is the moment it passes, all of a sudden these businesses pop up overnight, and you go from having 45 to 300. And if you have no recourse to do anything about it, the neighbors are complaining, so start planning ahead. If you do have any questions, feel free to send an email to marijuana@seattle.gov. And that goes both for the land use or the licensing. Thank you.
Let's go, Portland. We just have a few minutes, so we'll give you all the time that you need, though.
Yeah, because we're at, I think, like 4 minutes left, so
Yeah.
Do we want to go a little bit longer? I can shorten.
Yeah, let's go for it. We'd love to
All right.
hear from you.
All right. Sounds good.
Good job.
You seem like a fast talker.
All right, I'm going to try to talk as fast as I can here so we can get some of this information out. Once again, thank you to the City of Denver for inviting us, to Ashley and to Dan for putting on this amazing event to be able to connect and share how we're moving through the process. My name is Victor Salinas with the City of Portland, and I'll be talking about our application process as well as our zoning land use requirements and other local code requirements. We've gone through the site, so I'll skip that in terms of the comparison to the city. One of the things that I wanted to point out is when we as a city or as a municipality, we asked ourselves, do we want to regulate? And if so, why do we want to regulate? So we put together a team, and I spoke about this a little bit earlier, to figure out what it is that we wanted to regulate and the reasons why. We also convened a stakeholder group and did town halls to figure that out. And as a result, our local council adopted regulations that would address some of the concerns raised by stakeholders, including industry. And that was to reduce livability impacts, to minimize life safety risks, to mitigate safety and security risks, including controlling access to minors, and to also apply an equity lens in policy development. And what I mean by that is to look at some of the unintended consequences by the policies that we are developing, that you are developing. As you continue to develop your program or as it continues to roll out, how is it going to impact from a business equity perspective? How is it going to impact the communities that you're going to be, where these businesses are going to be located? So with that, the focus of our program is regulation through collaborative enforcement. Oh, I'm going to go, yeah, I want to stay right there. It's regulation through collaborative enforcement, providing clear guidelines and expectations to support the integration of these new businesses, the marijuana industry, into the existing business community, to control the illegal market, and to support and protect the regulated market as a result as well, and to mitigate potential harmful impacts. We do this by partnering with the state, with the county, and industry to shape sensible regulations and adapting to the realities on the ground and to the changing landscape and the needs of our city. I'm going to talk a little bit about our application process. And to start off with, I want to mention that we already had quite a few medical dispensaries, about somewhere around 150 to 200 medical dispensaries in the city of Portland already operating, since the state authority had already given registrations or a license, if you will, to these dispensaries. So we had to go back and work with them so that they were able to continue to offer their products, their medicinal marijuana, to their patients and not cut off the access to them. So we create a grandfather provision that would allow for existing medical dispensaries to be able to apply first and remain operational throughout the process. So in discussing a little bit about the process that we have to accept applications, applicants are directed to our website so that they can request an appointment and get all the information on the application requirements, as you see to the left there. The list of applications and requirements that they have to put together in order to submit a license. We then have an intake appointment so that we can go through the applications and let them know what they need in case they're missing any documents. And once they actually submit the application, we create a buffer. This buffer is based on the distance requirement that we have established, that council has established between consumer-based businesses and the distance to schools. From there, we go on to the application review and the inspection of the business, and actually create a physical footprint. We draw out the footprint for the business and create the permanent buffer. And lastly, we go in through and do a final application review, and then once the state issues the license or for recreational businesses or the registration for medical dispensaries, then we issue our license. So some of the minimum standards around zoning requirements, distance requirements, making sure that they have all the permits that they need through the state and through the city and the county. And we address the safety and livability concerns through our marijuana control plan. So the marijuana control plan is something that you can find online that is we make available in 11 different languages so that there are no barriers to be able to stay informed as to these businesses in the city. Talking a little bit about the land use, when we first began to have the conversation with our local government advisory group, we looked at special zoning designations for marijuana businesses, and ultimately what our council decided and landed on was to use the existing categories. And so for the purposes of marijuana, they categorized marijuana facilities into 4 distinct processes, so production, growing, processing, actual manufacturing of edibles, extracts, and so forth, the dispensaries or the retailers, and wholesalers. So the Portland Zoning Code defines these processes as, so again, production is agriculture, processing as manufacturing and production, dispensaries or retailers as retail sales and service, wholesalers as wholesale, and labs and research facilities as industrial services. With that, we partnered with our Bureau of Development Services to be able to coordinate, since they were going to need to provide proof of their building permits and zoning. So we worked closely to develop a process. But in the end, part of one of our lessons learned that I was going to touch on a little bit ahead is that because many of these businesses that had already located or purchased buildings or taken out leases, it was in buildings that were severely in disrepair and out of code and out of compliance. So the process really was slowed down because of the fact that they had to go back and retrofit the buildings, seismic upgrades, get them up to code, ADA, accessibility, compliance, and so forth. So it really it slowed down the processes, and as a result, we actually created an opportunity for businesses to request an extension on the deadline to submit documents to accommodate, because we didn't want to deny a license based on our bureaucracy or based on the fact that our agencies were not being able to handle the volume of applications. So talking a little bit about the distance requirement to limit concentration and not affect any particular area of the city, council adopted a 1,000-foot requirement for medical dispensaries and for marijuana retailers, the consumer-based businesses, that they had to be 1,000 feet away from each other and 1,000 feet from public schools, private schools, and parochial schools. So looking at our licensure, we've received a total of 487 applications, approved 93 licenses, and we've conducted 271 applications. That breaks down into 80 medical dispensary licenses, 11 for retailers, 2 for marijuana wholesalers, and 3 for producers. One of the things that I wanted to point out here is our interactive map that can be used both by community and by the, can't locate the interservice proxy. Okay, I guess that's not going to work, but so you see the map there, and this map is used for potential applicants that want to find out if they meet the 1,000-foot requirement from schools and from other businesses. So you can actually click on one of those dots, and it pops out an information block that provides the name of the business, the address, and it also has a link to that marijuana control plan that I mentioned serves as like a good neighbor agreement, so that it helps the business come in, as they're coming into the neighborhood, to establish a relationship with the community. In terms of the enforcement that we do, we focus on a collaborative enforcement. And by collaborative, I mean with a partner agency. So we partner with the OLCC. We've worked closely with Mark Pettinger and Steve Marks and the rest of the other folks at OLCC and with the Oregon Health Authority as well, to be able to mitigate these harmful impacts and being able to work with the industry. We know from our experience in licensing and working with the alcohol industry that there's like a 10-80-10 split, right? There's 10% of the actors are just innately want to follow regulations. They're rule followers. They want to know exactly how to be in compliance with everything. We're not worried about those because they came in, their applications were fully prepared, and they were good to go right away. Then we had about 80% of the population. They found out about our regulations and they want to be compliant. And they're persuasive. We can inform them on the value of coming into compliance and the need to come into compliance, really, with both our dual licensing process at the city and at the state level. And then we have also 10% of the actors, bad actors, that regardless of what we do, we're going to continue to struggle to bring them into the regulated market. But one of the things that we do know is that compliance begins with understanding expectations and the guidelines set by the regulating agency. And again, the focus is on meaningful enforcement and being able to provide that education to industry representative, to licensees, so that they know exactly how to be compliant with the regulations. As part of that collaborative enforcement model that we do, we focus on four major areas of compliance. The first one being around creating a present threat, violations that create a present threat to public health and safety, focused around operations that are illegal operations, those that are licensees that are selling outside of the licensed location, making marijuana available to minors, and transferring across state lines. Then going down to level 2 violations, those are not following the security protocol, staff, like for example, having a staff at the door that checks IDs and so forth. And then we have a level 3, which is not as severe, but for example, that they're not following the hours of operation. And lastly, our level 4 violations that are around not having their surveillance equipment, security and surveillance equipment up to date, that they, for producers, processors, and wholesalers, which are not supposed to be open to the general public, that they make their products available to the general public, that they have expired permits or issues with their air filtration system. So those are some of the things that we cover in our violation schedule. And we give applicants and licenses an opportunity to learn, to be educated, and to be successful in being compliant. So we offer the opportunity to first, whenever there's concern that there might be a violation, we issue a warning letter right away. That's the first step that we do to inform the licensee or the applicant as to what it is that they need to do to be able to be compliant, and to let them know, for example, many of the businesses that are now going through our application process didn't know that there was a City of Portland dual licensing process. And what we did through our warning letter is that we informed them about that process so that they can submit an application and be in compliance. So speaking a little bit about the lessons learned, I'm going to rush forward to the end there. Some of the focus was around, like I mentioned, avoiding denials based on the fact that our bureaucracy and the way that the agencies were working were not able to move through the applications fast enough. Other focuses were addressing some of these loopholes that folks were talking about, right? So in transferring of licenses or transferring of ownership in applications, we knew that we were going to be able to avoid it completely. And because these applications were becoming a hot commodity because of the 1,000-foot distance restriction, we were accepting applications in the order received. And so, for example, if application A submits an application and application B submits for a location within 500 feet of application A, then application B would not get licensed if application A gets licensed. So all of a sudden, their order in line was becoming, very, very valuable. So we established a process where if there was a transfer of ownership of 50% or more, it would be considered a new application. It was 49% or less, it would be just an update to the application ownership. And we did that on our licensing side as well, but we put an added parameter so that there was not an additional loophole. Licensees that wanted to do 50% or more would have to submit a new application. And those that did 49% or less could make the change, but they could not make a change of 49% or less more than one in a 90-day period, so it would slow down the process. So those are some of the things that we did. We also focused on coordinated enforcement and also increasing the capacity and knowledge and effectiveness of our community to be able to stay informed and engaged in in policy decision-making processes. So those are the focus that we had. Sorry, I'm trying to get to your next slide. I know we're coming to the end here. So looking ahead, we're looking at policies that impact delivery, policies to ensure that that we are being good partners in youth access prevention, and other issues that come up as the state and local policies continue to change. Those are things that we're looking at, including substantive amendments to be able to maneuver through, as everybody else was talking about. We're constantly evolving and changing. I mean, it's kind of like we're raising a child. We're going through the steps. What is it? The phases and steps of raising a child. And so it really is. We know very little right now. Thinking of myself as a new parent, we know very little right now of the industry. And so as we continue to go, we're trying to add and amend and enhance the regulations that we have and the policies that we have to meet the realities on the ground. So some of the things that we're looking at is again, allowing for delivery in the city of Portland. Another area that we're looking at is whether we want to uphold the existing building codes to be required at application process and as a requirement for a licensor. And one of the things that we're landing on is that they were saying that sometimes these building upgrades are costly and applicants don't want to go through the expense if they ultimately are not going to get licensed, especially if they're not the owners. So one of the things that we're considering is for producers, the cultivators, the wholesalers, the retailers, and the medical dispensaries, having them apply for the required permits and the change in occupancy if needed, and then wait for the upgrades until after they get licensed, and that would be, that would be on them to continue that process. But that way, they wouldn't be required at the beginning. One of the things, though, that we do plan on continuing to hold on to is those building code requirements. And we're evaluating that right now, those building code requirements for processors, the ones that do extraction, because there's a huge life safety and risk of loss of life. So for those reasons, we're interested in keeping those requirements at the application and licensure process. And lastly, one of the things that we're creating, as I mentioned in our earlier presentation, one of the things that we look at is applying an equity lens, and that's looking at business equity and equity and inclusion in the decision-making processes, right? So from a business equity perspective, we realized that going into the industry, the capital investment that's required to start up a business is considerable. And so one of the things that we did as a recommendation is to consider a retail courier license. So this would be a license where a licensee would not be able to sell on-site. They would only be able to sell by delivery, and thereby lowering the capital investment cost considerably, because the building code requirements would be different than that for a brick and mortar, where there would be people coming in to the businesses. So thank you for having me here. I know I rushed through this. I think if there's anything that I'd like for you to take away is, from a perspective of equity and inclusion, it's much easier to apply an equity lens at the beginning while you're developing these policies than to try to retrofit them at the end. So I'd be happy to provide technical assistance, share some of our experience, so that you can be successful in applying this equity lens and to make the policies that you're making better for the community. Because at the very end, that's why we're establishing these regulatory programs, right? To serve the community. And that way we ensure that we're serving the entire diversity of the community. So thank you.
Yay. Thank you very much, especially to Sherry and Victor who've joined us today, and of course for our team in Denver.